Mr. and Mrs. Gray and the Johnsons appeared before Judge Judy to settle a dispute between them. The Grays have been neighbors with Bob Johnson for 20 years, since 1997, and Janet came into the picture in 2007. The Grays have 3 cats, while the Johnsons have 2 small dogs, a Pomeranian and a Papillon. The Grays discovered a pigeon spike trap that the Johnsons had put up behind their shared fence to keep pigeons from landing on rooftops, which the Grays found concerning. The Johnsons explained that the spikes were put up because of a possum problem in the neighborhood and to protect their dogs. The Grays took down the spikes before speaking with Mr. Johnson, after calling the local police department to determine whether it was legal. The Grays and Johnsons agree that the fence is a shared property line fence. Judge Judy returns the spikes to the Johnsons and admonishes Mrs. Gray for speaking out of turn. Mr. and Mrs. Gray appeared in front of Judge Judy in a lawsuit against the Johnsons, who were their neighbors. The lawsuit was about the Johnsons having sprayed a tree on their property with a toxic chemical that caused damage to the Grays' property and health. Before addressing the main lawsuit, Judge Judy asked Mr. Gray about his past interactions with the Johnsons. He said that he had taken down a structure that belonged to the Johnsons on June 3, 2016, after their cat was injured with a puncture wound. Gray said that he had informed the Johnsons that he had to take it down and had also called the local police department, who told him he could. Judge Judy asked the Grays about their efforts to keep their cats contained on their property, and Mrs. Gray said that they pretty much lived in their garage and went in and out. But Judge Judy wasn't satisfied with their answer and told them that they have a responsibility to keep their cats in their house to avoid any further conflicts with their neighbor. The main lawsuit was about the toxic chemical that the Johnsons had sprayed on the tree. The Grays claimed that the overspray had caused illness and that they had to clean their air conditioning system. Mrs. Gray said that they had breathing problems, but Judge Judy asked for a medical certificate to support the claim. Judge Judy asked to see a picture of the tree and confirmed that the majority of it was on the Johnsons' property. The Grays' complaint was that the Johnsons had sprayed something on the tree that had caused damage to their property and health. In conclusion, Judge Judy listened to both sides of the story and asked for more evidence to support the Grays' claims before making a decision in the lawsuit. Mrs. Gray also claimed that the malathion was not diluted as it should have been. However, Mr. Johnson stated that the malathion was bought from Home Depot and was applied on the tree to get rid of an aphid infestation. Judy asked for evidence and the hazmat report was presented, which stated that malathion was used. Mrs. and Mr. Gray also presented their side of the story and claimed that Johnson's mixed the malathion with another pesticide, ortho-spider spray, which is a no-no. However, the judge asked for evidence that it was contraindicated on either of the containers. Mr. Johnson's explained that he was a retired deputy sheriff and used to work in pest control. Judge Judy explained to the Grays that they had to prove negligence, either that Johnson's mixed the 2 pesticides together, even though it was contraindicated on the label, or that he sprayed it maliciously, which they had no evidence of. The only way to prove negligence was to show that Mr. Johnson's did something wrong, not just that Mrs. Gray inhaled the vapors and got ill. The Grays claimed that Mr. Johnson had never warned them that he would be spraying on a hot day with the windows open, and that they had called a hazmat team because they couldn't breathe due to toxic fumes. Judge Judy listened to both sides of the argument. Mrs. Gray claimed that a hazmat crew had come to their house, but Mr. Johnson denied calling them. Mrs. Gray also claimed that they had gone to the hospital because she couldn't breathe. The girlfriend of the plaintiff's son also added that the chemical spray must be diluted, but there was no proof that Mr. Johnson had failed to follow these directions. However, Judge Judy stated that the Grays' sickness was irrelevant to the case, and that they needed to prove negligence. They needed to show that Johnson had failed to follow the instructions on the chemical spray bottles, which stated that the chemical must be diluted before use. The girlfriend of the plaintiff's son claimed to have seen a portion of the paragraph on the bottle that stated, "Do not apply or allow to drift to blooming crop or weeds." Judge Judy told the Grays that they needed to prove that Mr. Johnson had failed to dilute the chemical, but the Grays couldn't show any evidence in the report that it was supposed to be diluted. Judge Judy concluded by stating that the product was sold over the counter at Home Depot, and that it was up to the Grays to prove negligence on Mr. Johnson's part. The neighbor's girlfriend's son argued that they didn't have a picture of the directions, only a picture of the warning. Judy explained that it was their burden to have a picture of the directions, in order to demonstrate that either bottle says, "Do not combine together, must be diluted with so much water." However, Mrs. Gray stated that she couldn't find the malathion at Home Depot, even after asking the store. Judge Judy suggested getting it from another store or Amazon. Mrs. Gray then said that she had asked the hazmat people who were present but was told that the Malathion was not sold there. Judge Judy responded by saying they were done with the discussion, as there was no indication that the neighbor had intentionally caused injury. Mr. Gray, Mrs. Gray's husband, then added that there had been a construction crew in their driveway 5 to 6 weeks later, cutting dangerous resin countertops, which blew onto all of their vehicles and into them as they were working in the garage. He claimed that the crew didn't warn them and that the gentlemen working were wearing respirators to protect themselves. The judge noted that the couple had been living next to each other for 20 years and asked about the first incident of difficulty, which was in 2016, almost 20 years after they had first moved in. In the courtroom, a girlfriend plaintiff's son appeared before Judy with a very important issue. The judge asked him to sit, but he insisted that the information he had was crucial. The judge listened and allowed him to continue. The plaintiff's son told the judge that he had found the information she was looking for. The judge listened and then asked about the case. The plaintiff's son told her that the case was about a dispute between neighbors who had lived next to each other for 20 years. He explained that until 2016, there had not been any difficulties between the two of them, but the situation changed when spikes were erected in the backyard. The judge asked about the date of the first difficulty, and the plaintiff's son told her that it was June 3, 2016. Gray tried to speak up, but the judge asked him about the case and he didn't respond. The plaintiff's son then showed the judge the evidence he had found, which was a warning label that said, "If inhaled, remove person from exposure area." The judge commented that the plaintiff's son did the right thing by removing himself from the exposure area. The plaintiff's son continued by saying that he and his girlfriend were never told that the area had been sprayed with a toxic substance. They thought there was a gas leak and panicked, turning off all the gas and unplugging things. When the gas company arrived, they realized that it was not a gas leak but a spray. The gas company never told them to leave the area, even though they were inhaling the toxic spray. Judge Judy listened to the evidence and told Mr. Johnson that next time he should get some expert advice while spraying his trees. She also told him to keep his cats inside. Mrs. Johnson then tried to bring up a countersuit, but the judge told her that they were done and there was no need for a countersuit. Mrs. Johnson tried to bring up a police report, but the judge repeated that they were done and to take her wife and leave.